Typically, when we reach a plea deal on a DUI case, that means that the case has not been dismissed, and you're typically pleading to a DUI or a DUI with prior DUIs, or maybe a reduced charge to what's called a wet reckless. Consequences, let me first start with probation. Typically in Marin County, when you're put on probation, it's unsupervised. And on a DUI or a DUI with prior, it's usually a 3-year probation. That means stay out of trouble for 3 years. And if you do get in trouble and they want to violate your probation, you'd be facing typically a maximum of 6 months in jail on a first DUI, 90 days in jail on a wet reckless is the maximum penalty there. Or if it's a second offense, you'd be facing up to a year in jail. Same with the third offense. Now, the nice thing about California is that if you were found in violation of probation and you get a hearing in front of a judge on the probation violation, if it's not negotiated, then you would do half time. So a year would be 6 months is the most they could give you. And for a DUI, instead of 6 months, it would be 3 months. And typically on a probation violation, you do more like, a handful or weeks worth of time, which can often be done on the sheriff's work program, some type of alternative services instead of actual jail time. But when you have multiple DUIs, the odds of having to actually do jail time increase. So that's one of the consequences, potential consequences when you do accept a plea deal and plead guilty to your case in Marin County. Other things are fines, and there's different amounts of fines depending on what type of a DUI it is, whether it's a multiple offense, a first offense, or a reduced charge to a wet reckless. DUI school is something that you would normally have to do when convicted of a DUI in Marin County or anywhere else in the San Francisco Bay Area. And that the length of the class would often be determined by whether it was a first offense, a second offense, or multiple offense, or a wet reckless. And typically on a first offense, it's a 3-month DUI school. It's about 30 plus hours. And you would need to complete that school in order to have your license be reinstated by DMV. That's another issue. Let me kind of segue into the driver's license. So there's a separate administrative hearing that happens if it's requested within 10 days of arrest by your attorney, or you can request it yourself. I always advise having an attorney requested. And that is DMV is trying to suspend your license. So when you get convicted in court of a DUI, that results in a license suspension as well. And we need to, get you into a restricted license. So you could get an ignition interlock device or be on a work restriction or just go without driving. And there's a lot more to that. So we want to, go into a lot more detail with our client about that. We do that in our initial consultation and throughout the pendency of the case. We answer all questions about this because it is kind of tricky. You need some additional insurance to get that restricted license. It's called SR22 insurance. If you need an ignition interlock device, you want to make sure you go to a good company that's going to do that, who's got good customer service. We can give you, some information on that as well, who we think are the more trustworthy companies there. Other things that can happen with a DUI, other potential consequences, it's priorable, whether it's a wet reckless or a first offense or a multiple offense, it counts as a DUI. So it is priorable for the next 10 years. So if you get a wet reckless and then get another DUI within 10 years, the new DUI would count as a second offense. And that just means it would have a much greater potential penalty. Other things, while you're on the probation, you cannot have alcohol in your system when you're driving. Some of these cases, the disposition, which is agreed to, and then you'd have to sign off on all this, say no drinking at all, or no use, possession, or transportation of alcohol. That's typically in cases where it's a multiple offense. You have a prior DUI or more than one. But the no alcohol in your system is a requirement while you're on that probation. If it's a wet reckless, it's typically a 1-year probation. A regular DUI is a 3-year probation, and typically a second DUI in Marin is a 3-year probation. So that means that you cannot have any alcohol at all in your system when you're driving while on probation. A lot of other consequences. You give up certain constitutional rights as well, which we go over with you before any plea is done on your behalf. One of the nice things about having an attorney in Marin County who knows what they're doing, who focuses on DUI defense, is they can typically do most, if not all, of the court appearances for you. So you usually don't even have to appear remotely. We can do everything for you, get you all the paperwork if and when it does come time to complete the case, if there is going to be a plea deal, and then we go over everything with you. So there are a lot of potential consequences, and it does take time to go over them, and we need to make sure that you understand them. One last one is that they make you sign and acknowledge a waiver that says that you understand if this happens again and someone gets killed, you can be charged with murder. That's a Watson advisement. And so the court will make sure that that has been signed off on and that we've gone over that with you. Other issues and consequences do exist, but that's a handful right now, and I'm always happy to go over all the potential consequences with anyone who has questions about them, whether they're my clients or someone looking for advice.